too, but I want to remember his questions because there's so many questions. Oh yeah, you have been careful. Me, I have to remember.
Ladies and gentlemen, can you please take your seats? Welcome everybody to this Bruegel event on the question whether the EU copyright directive is still fit for purpose in the age of generative AI. Generative AI is something that we've all heard about, ChatGPT, large language models, and some of you have probably been using it in search engines. But it has many implications for copyright protected media content. And basically in two ways. One is on the input side of generative AI models. Generative AI models use a lot of copyright protected content from the internet or from other sources for the training of these AI models. And the question is whether copyright should be enforced there, in the sense that the trainers of these large models should pay a license for the use of that copyright protected content, or whether it should benefit from an exception on copyright protection. And in Europe, for example, we have the text and data mining exception that could be applicable. On the other side, generative AI also has an impact on the output side. It can produce media content, music, text, film even. And the question is, should that benefit from copyright protection? Or should we stick to the rule that only human-generated creative output benefits from copyright protection and not machine-generated output? So policymakers have several options here. And the question is, which way would they go? Would they go for more protection of copyright holders, or would they lower protection to stimulate more innovation? In the EU, in continental Europe at least, we are more in this continental perspective where we see copyright as a right to a remuneration for authors of creative content. And so this emphasis on remuneration makes it very difficult to take a more broader economic perspective like we have in the Anglo-Saxon approach, where copyright is more an economic policy instrument to stimulate investment in innovation, but also to balance the private rights of authors with the interest of society at large in terms of having access to innovation and facilitate the spreading of innovation. So the question is, which side will policymakers like to go? Any change in technology, like generative AI, for example, affects that balance between the private rights and the more societal rights. And so the question is, how will this play out here in Europe? We have three very distinguished members of our panel today to discuss this issue. Estelle Derclé, she is professor of copyright at the University of Nottingham. She has a very long academic CV, which I will not go into details, but some things are worth mentioning. She was a past president of the European Copyright Society. She worked on many panels and studies for governments in the UK and in the European Union on copyright issues. And she also practiced in a private law firm here in Brussels on copyright issues. Estelle, for me, is our representative of the law scholar view on copyright issues in this panel. Jeremy Rolson is the Director of Government Affairs at Microsoft here in Brussels. Prior to working for Microsoft, he worked for Nokia, he worked for the EDIMA, the European Digital Media Association, in which capacity he was also very active on copyright issues and notably on the 2019 EU Copyright Directive. And of course, Microsoft is one of the front runners in the use of generative AI, its own generative AI models, but also close collaboration with OpenAI, one of the most advanced companies in this domain. So for me, Jeremy represents the platform industry, but also the AI industry in this panel. And then last but not least, we have Axel Voss, who is a member of the European Parliament for the European People's Party since 2009. And since 2014, he sits on the Legal Affairs Committee. and very important for the subject of discussion here. He was one of the main drivers, and he was actually the rapporteur on the EU Copyright Directive, the 2019 Copyright Directive. So he was in a driving position in that case. And so, in my view, he represents the policymaker's perspective in this panel. So let's turn first to the inputs side of the debate. So as I said, on the input side, the Commission or policymakers in Europe have a choice to what extent they will apply copyright protection to inputs. In the Commission's draft of the AI Act and subsequent additions by the European Parliament, there's an Article 28b, paragraph 4c, that says generative AI model developers should make publicly available a summary of the use of training data that they use in the training of the model. And they should ensure that models are trained in compliance with EU copyright law, in particular the opt-out for the TDM, the text and data mining exception. So how do we interpret that, and what are the economic implications of this option? In the UK has tried in 2022 to have a more general text and data mining exception for generative AI model training. But that proposal was withdrawn by the government because there was too much opposition from copyright holders. In the US, we have fair use and transformative use doctrines that allow ostensibly more leeway for use of inputs for training generative AI models. But there are many court cases ongoing, and it's unclear how they will end up finally. In Japan, there's a noteworthy exception in copyright law that says an exception to copyright is granted when the content is not used for human enjoyment. That is for the primary purpose for which media content was produced. So that seems to be very open to using copyright content for training of generative AI models. So let's start the debate on this. We have 3 speakers. Each of them will get 5 minutes to answer a number of questions that I will ask. And the audience can also ask questions on Slido. On Slido we have a hashtag copyright, which you can use. Also, if you're sitting in the audience here, you can use it. But we also have an online audience today, so they can use this to ask questions. And I will seed it on my little Lenovo tablet here, and I will select a number of questions. At the end, we'll try to keep about 15 minutes for a Q&A session after we've heard the views of the panel. So let's start with Estelle and the legal scholar's view. Estelle, as an economist and not as a law scholar, I see 3 reasons why the copyright exception for training inputs would be a very good thing to do. First of all, using copyright content as training input will not be a substitute for using music or films for their normal outputs, so it's not a competition on that side. Also, not granting a copyright exception would make the development of AI more expensive, and that would slow down innovation. And thirdly, if in the EU we do not grant a copyright exception, we may lose comparative advantage compared to other countries and regions that do allow this copyright exception. So do you think, as a legal scholar, that this would be a good thing to do or not?
Thank you very much, Bertin, and thank you for inviting me. Yes, I don't think, first of all, I think we have to have a very nuanced reply to these issues because there are different types of AI. I mean, you're concentrating on generative AI. When the TDM exception was adopted back in 2019, nothing like this existed. So it was already, I think, outdated to some extent. But I think it's not true to say that there's no impact, right? I mean, you just have to see the strikes in Hollywood, the writers being sort of somewhat substituted and you know, journalists as well and stuff like that. So there's very big problem with generative AI. So I don't think it's totally true that it doesn't replace authors. So there are also obviously risks. I know we're not talking about the risks, but there's security risks, the hallucinations or confabulations or falsities, whatever you want to say about AI is not perfect, right? So I think in terms of impact, there will be impact. And it's not only me saying it. I mean, I was just reading on the train something by an economist, Stiglitz, who's the Nobel Prize of Literature a few years ago, and he was saying that, I try to reproduce the quote, but he said something like, unfettered capitalism and unfettered innovation is not conducive by definition to the well-being of society. What we want is the well-being of society. So you got to be careful about saying, generative AI, no impact. So I think when the TDM exception was adopted and how I interpreted it, and Axel can sort of, and Jeremy maybe can comment later, it was really the use of AI to cure diseases, to do other things. And like you say, in Japan, not enjoying the work as a work. And so that I'm very pro. I mean, I think the AI will revolutionize medicine and everything we can think of. But in terms of copyright and texts and music and things that are made for enjoying, films, etc., it does already replace artists. So I think that's one thing. Now, yes, it's true in the economic sense. If we have a complete opt-out for training data, so you just scrape the whole web and you don't ask a license, and you don't pay therefore the right holder for a fee, it will definitely be very cheap. And it's already happening. A lot of stuff that's generated by AI that costs nothing and people can reuse, etc. So yes, it will be cheap, but the problem is you need to find a balance between, okay, what do we want in society? Do we want only generative AI outputs to consume as consumers? I think probably people are not too happy with that, and then we're probably going to pay a premium for real human stuff because we don't want to be flooded by AI stuff. And then you have to think also, okay, if we put creators out of work, then you have nothing more to add to the training data, nothing new, and so new by humans, that is. And so the training data, they'll generate stuff, but it will be repetitive, or they won't find more. There won't be more input to put in. You see what I mean? That's why I'm thinking you need to find some sort of balance. And as I say, I'm not against generative AI as such, and I will say more when you ask me the other questions afterwards. Now, in terms of the yes, this whole debate with the database directive was the same. We're going to have this law, and therefore we're going to have all these database producers coming to Europe where the sui generis right, and we increase the EU's competitiveness. So it's the same thing here. I mean, if Japan does something different, or the US has fair use, and generative AI, it can bloom there, but we're very restrictive here, and we impose this remuneration for artists. Therefore, that means, we're not going to be competitive. So I think wait, because we have these litigations, as you said, in the US and in the UK. Actually, there's Getty Images against Stability AI, and it will be very interesting. I hope they don't settle, because then we have the judge's view and the application of the current law, so we know where we stand, and therefore afterwards, if we're not happy with these decisions, then maybe the legislator can do something to change. And I'm actually quite happy the UK has not rushed into it and is taking a back step and taking will it wait and see attitude to see how they're going to do it. And one of the things which is really interesting in the Getty Images Stability AI this, litigation currently in the High Court in the UK is their claim. So they're claiming that they basically trained the Stability AI trained its machines with Getty Images. So there's a copyright claim, but there's also a database sui generis claim. So that is something that will be very different, because in the US they don't have it. I think it's a bit flimsy because Getty is based in the US. I mean, they're claiming they have a subsidiary in Europe somewhere in Ireland, not in the UK, because we still have the database right in the UK, but it's a pure UK right now. It's not an EU right anymore because of Brexit. But so it will be very interesting to see how the courts deal with that, because that will have repercussions for here in Europe with the database sui generis right. So I think, that's all I wanted to say. For now, I think we have not rushed and have a nuanced answer to this.
Yeah. Thank you very much, Estelle. Jeremy, in your previous life, you have been very active in copyright and also in advocating the text and data mining exception, if I'm not mistaken. In your current position at Microsoft, and Microsoft as a major driver of the generative AI revolution, on the one, do you see that, would you be in favor of a generalized TDM, text and data mining exception? On the other hand, I see that Microsoft and several other of the big AI companies are moving towards getting to an agreement with companies like Getty Images or others that have a lot of copyright protected content. So seems to be some willingness to pay as well for a license agreement, and how would that work is something I wonder. So there is this ambiguity of these big companies between trying to get the exception, or the other hand willing to pay. Now big companies can afford to pay maybe because they have deep financial pockets, but will that reduce competition in the AI field because only the biggest ones can pay and the smaller ones fall out? How do you look at these questions?
I'm glad you asked the question that way, and I'll borrow from what Estelle said, that it's always a very nuanced answer to some of that. Even the latter part of the question about licensing, you have to look at what the trade-offs might be there, and there are trade-offs of who would be favored by that type of approach versus another. Coming back to the earlier part of your question, and maybe the question for the panel, if you go back to what that debate during the copyright directive was focused on around text and data mining, I think what came out was a good balance, because there is a balance there. It is not a generalized exception that is open for anyone for any purpose. It landed on a space where if creators, rights owners, do not want their data to be used for text and data mining, they have that possibility. That's an important control. There are certain business models for whom that was very important. So if somebody doesn't want their data used for training AI, they're entitled and have that possibility to prevent that. And we should talk more about that, whether the tools are adequate and the tools can be improved. But that would be a discussion on the tools side of things. I actually think the exception is it's a very European way of looking at it. There's other jurisdictions that you mentioned that have other culture in this space to look at it differently, whether it's fair use. But the exception seems to be, if you're going to go down the route of providing an exception, which we have, then I think the one that came out was adequately balanced. I think, let's not forget that I don't think, as you said, anyone realized how close generative AI would be and how around the corner that might be. But the Commission said it very well, that this was an exception meant to drive and enhance and contribute to Europe's ability to leverage machine learning and AI. We envisioned this, but it still was a balance. It didn't mean that it was open season for everyone. There were opt-outs that could be expressed, and we'll talk about the ways that you can express the opt-out. But I think it is the right type of balance. Alternatives to that would come with significant trade-offs. If you were to consider an opt-in approach, I'm not sure I think that would stifle innovation outright. What the default should be, and I think the statute is actually really clear, and we talk about current debates, it's premised on lawful access, right? So a lot of the discussions we're having now, I don't believe are arguments for the creation of new law. I think it's an argument for the enforcement of existing law. And you can talk about ways to demonstrate compliance with the opt-out, the processes you have. But perhaps a higher level point is so much of this that we're going to continue to discuss. If we're not going to stop discussing it today, we're not going to stop discussing it after the AI Act. Shows just how important it is to be able to talk about this further. I don't think in a rush to get a policy adopted, putting a last minute amendment in, capturing a huge space that hasn't yet been discussed adequately is probably the right way to do it. We're going to have this conversation. We should have this conversation. We should have this conversation in a copyright context and all of the trade-offs that would need to be implicated with that. But AI requires a lot of data, both on the input side, and I like the way that you framed it. There's a distinction, I think, to be made between some of the concerns around the outputs versus the inputs. But it's also important to remember there's no one piece of data that is important to an AI training. It is the patterns from large data sets that go into that. So, pulling out one piece of data isn't going to destroy the model, but it is important to have access to the widest amount of data possible. And I think that the copyright directive, whether deliberately or not, I think it was actually pretty deliberate. It might not have seen generative AI right around the corner, but it was meant to facilitate this development. And just to final point, remember some of the trade-offs that we have. The harder it is to rely on training data from Europe, that has implications for the type of models that will be released and how much data was used to train them. Is it European data? Is it only data from other jurisdictions? Would some of that training go outside of Europe? You made the point about bigger firms versus smaller firms. You can bring in the licensing point there, but you could also bring in some of the potential burdens that might be placed in terms of demonstrating these summaries and the like. So there's trade-offs to consider. I think you need to talk about that, and we will talk about that. I hope we have time to talk about it so you come to another balanced arrangement where we have solutions that are actually aligned with some of those broader objectives in AI.
Thank you. Axel, as rapporteur at the time for the EU Copyright Directive, you were one of the main architects behind this copyright directives, including the TDM exceptions in that copyright directive. When you listen to what the two previous speakers said, would you do things differently now than what you did at that time? Because at that time, of course, generative AI was not on the horizon yet. But when we listen to what's now there, don't you fear that the way we formulated the TDM exception in the EU Copyright Directive, there's a risk that Europe will fall behind because other countries are more generous in the use of that? Or don't you fear that it will only be accessible to large companies that have the money to pay for licensing of that content? How do you look at this nowadays?
Yeah. Thanks. So thanks for organizing this meeting, this exchange, and also for having me. This is one of the most important questions right now, how we are looking at it. What we can't allow as a legislator, that someone is inventing a kind of a new digital tool and all of a sudden you are getting problems with one subject like copyright, that this is then not existing any longer. So as a legislator we have to say, oh, these are existing laws and you have to respect it. So I can understand the enthusiasm in developing something and not thinking on every detail, but then afterwards, of course, then we have to correct it, and this is what we are trying to do here. The Commission has kind of an approach to it, like Article 4, this commercial text and data mining from the copyright reform, what I would consider is not really valid for this point here. We thought at that time, we never discussed AI at that time, we never discussed large language models at that time. And so this was meant also from my understanding, there is a company who is looking for some information, doing this text and data mining and getting some out of it for your own purpose. What we are having here is you are searching a lot of data or training your algorithms on these, and you make these publicly available in a kind of an output. So this is, from my understanding, a different use, and that's why I would say Article 4 is not really the right way forward. If we are looking to these machine-readable issues where you can put stop signs in front of text and data mining projects, this then might be helpful at that time. I'm not so far that I would understand how this is working. I would consider they are ignoring these right now, these stop signs, and not with a bad intention. It's just like the machine might be developed, they are ignoring these. And then we are coming also to the different interests of the creative sector. So newspaper, for instance, would like to allow the use of the texts, but would like to be remunerated. And so music also, it might be different with movies, because they would like to have their own distribution and so on. And here I'm asking myself if this is somehow possible in inviting these machines on the one hand side, but then saying if you are then there, you have to remunerate. And here I would say this is something what we have to clarify on this technical level, somehow what is possible. On the other hand, of course, other things are coming into my mind. what we can't regulate right now in the AI Act, but what we have to do afterwards in the next mandate is things like how to detect copyright holders, how can you still remunerate because you have a global model in place, and now it's probably asking too much in detecting every single copyright holder and then trying to find a kind of a licensing or system or whatever it is. On the other hand, we have some, when I talk to them, some songwriters and composers, not the biggest one, smaller ones, they do not want to be part of a collective management system because it's cost them too much. So therefore we need somehow to single out at first practical problems, and on the second level then to find solutions for it, how we can move on. I would like to do this next mandate if I have the possibility to come again to the parliament and starting these discussions. And here I hope that we can then find some practical solutions, not always in the intention of a legislator, but it's for us, or for me, it's more important that the creative sector is satisfied with a kind of a way forward, and still on the other hand side that the AI providers or generative AI providers might still act in a way they would like to act, and we are not complicating this. If there is a solution, I don't know, but we should figure this out. Therefore, I would say the copyright directive is not made for a tool like this. Here we have to think about, we can have a fundament of these ideas, what we created there, but we need to adapt probably to this new way of technology. And that's why I would say we need these adaptations, but we can't do it now in the AI directive. Sorry, regulation.
Yeah.
The act. Yeah.
Thank you. So let's move to the output side of these generative AI models and their ability to generate nearly perfect substitutes for human-produced creative outputs. Now, for the first time in history, this is possible, that a machine can produce a creative output. And this is not foreseen in copyright law. Copyright law only normally attributes copyright to human outputs. Well, there are a few exceptions in some countries. But to me, as an economist, it seems that whether we do attribute copyright to generative AI outputs or not, we are damned if we do and we are damned if we don't, in the sense that if we do not give copyright to generative AI outputs, they will be sold at marginal cost. They are not protected, and so it's only the cost of replicating, of distributing them, that will matter. And so they will be very cheap, and they will flood the market, and they will overwhelm human copyright protected outputs that will be sold at a much higher price. On the other hand, if we would attribute copyright to generative AI outputs, they could be sold at a higher price, but still they would compete with human output, and they would anyway substitute for them. And humans would probably want to produce mixed outputs where there's partly human input and partly machine input or output. And then the question comes, what would be the de minimis human content before you can qualify for copyright? And that lawyers have lengthy debates on that. So this is very difficult, how to solve this. And as an economist, I don't see solutions, but maybe lawyers may see a solution for that, Estelle. So are you in favor of granting copyright to generative AI outputs? And if so, why? Or if not, why not? And wouldn't you fear the economic consequences of doing it either way?
Oh, sorry, I thought you were going to ask me another question. No, I would say we have had so far a nice little experiment, right? All this flourishing of generative AI, open AI, stability diffusion, there's loads of them. I haven't had any law protecting sort of their outputs, and have done it with scraping the web, or sometimes they've asked licenses, but most of the time they haven't. So you see that they don't need protection because they just did it, and they don't seem to be running out of money, right? So if you take the pure economic rationale behind it, then they don't need to be protected. The outputs don't need to be protected. Okay. Now you're right to say that if we do that, we leave it, and that this is going to have the horrendous consequences. They flood the market, and so that they will replace human outputs. So my view is no, because if the outputs are so similar to, or they basically, even it's not a question of similarity in the EU. Is they take the intellectual creation of only a little bit. In the InfoPack case, it was 11 words could be protected by copyright, and in my view even less than that, because you just take the creativity of the author of one little bit of text or one little bit of a painting, you're still infringing. So on the output side, I'm not too worried that if the outputs are replicating to some extent or taking the creativity of the author, they infringe. So there'll be lawsuits on that point. So that's not too worrying. But giving them protection for the outputs that are not, taking the creativity of the author, they don't seem to need that protection right now. They proved it to themselves. They shot themselves in the foot in a way. So that's one thing. Now, what do we do with this co-creation problem, right? What if somebody, a human, use ChatGPT or GPT-4 or whatever generative AI machine you want to use, and then they create something with it? I see this is wonderful, okay? I don't see there a problem. As long as, of course, the input side problem is resolved, there's licensing or whatever the solution is, then they're fantastic tools. It will reduce the amount of time that humans take to create certain important things like reports or newsletters or things, and then you improve that. You, as a human, you'll improve it. Now, the problem is to figure out how much should then the human have in terms of their own creation into that stuff that's generated by the AI. And that's where the transparency obligation comes in, right? There needs to be a system where you have to declare one way or another that you've basically generated some of your text by AI, and then the rest is your output. And that I have no idea how to solve, because how are you forcing people to basically be transparent about what they do? It's a very difficult thing. Watermarks, I don't know. There must be some sort of technology that's enabling like traceability of generative outputs, and probably Jeremy has more on the technical side, more to say about that. But I don't think that we should then say, oh, because you created something with an AI and sort of improved it or gave them a really, really good prompt and something really cool comes at the end, oh, then the human has no copyright. I don't think that's fair to the human. That's really being creative in doing so. So I think the law will have to adapt to that, yes. So far, I don't think on the output side, we don't need to adapt the law. It's very simple. Just apply the current copyright law that we have to beat the infringements of generative AI, sort of infringing current works of artists, and that will solve that problem. But then the co-creation, so you create stuff with AI and then who gets what kind of right, that's a bigger debate, yeah.
Jeremy, how does the industry look at this?
Well, yeah, I can't speak on behalf of the entire industry, but I can say that our position on that is actually quite clear. We think that these outputs would benefit and should benefit from copyright protection. And it's because I might be a little more precise. I can think of very few instances where these AI-generated outputs don't have a human controlling those generated outputs. It doesn't just do it. I mean, you have to give it instructions. You have to use these tools. There's always a human element to that, and I think the human, regardless of what tools they're using, should benefit from the outputs that they're creating. They may be using this tool, which is incredibly powerful, to do it, but it's still prompted. If you and I use the same tool, we'll have different outputs. I think the degree to which there's human involvement there is, very few instances where that's not the case. If you look at even the way our services have been branded, we refer to this as a co-pilot, and it's very much based on what decisions the humans are making to leverage these models accordingly. So I think the output should benefit from copyright protection. I think it'd be unfair for it not to. But that's on the output side. And then you come back to the input side, and I think there's still some nuance to be understood there. You know, the training data is much different than the output data. You know, you're training this to understand patterns and the like, and it's from those patterns that we're creating these outputs. But to answer the question, you know, more clearly, I think, yes, they should benefit from those outputs. I can appreciate, and we contribute to many of those transparency exercises that you imagined, whether it's in a search context. You can see the way that, again, you get an answer to your question that's based on sources from a variety of different ones. And you can use footnotes. You can say, you know, here's where you can go to learn more. You can say more about how you came to that answer. That's fair. I think on the watermarking side, there's a lot of interesting initiatives, particularly in audio and visual, where that can mitigate some of the concerns people would have. You think about deep fakes and the like. But I also think it's important to remember that, you know, copyright is there as a protection of the expression of ideas, but the ideas themselves. You know, if we could make this a bit more provocative and think about it, you know, you are supposed to be inspired by styles of others. There's nothing against, you know, leveraging a style. Now, if you copy and paste an artist's painting, that's different. But if I'm inspired by an artist's style, I know that it might get gray sometimes as to how derivative that might be and where the moral rights might be. But courts have taken, you know, precedent in a lot of spaces on that. But think about the implications if you were to go down that path. You know, we use the example of Monet and Impressionist painters. Think about how much innovation in the artist world came about from painters leveraging that style, right? Think of what would have happened if the style would have been copyrighted. So I think, yes, generative works should have copyright protection, and I think it's not important to remember what the purpose was of this in the first place.
Can I reply really quickly, just to see if we're on the same, we're talking the same language here? Because obviously, if your prompt is draw me a cat in Van Gogh style, I think that the output should not be protected, because first the human has just given an idea, and second the AI has just trained, and basically it's not a human. Don't tell me there's a human behind, you know, manipulating the AI. It's just a computer. And in the UK we have a computer-generated works provision, but you can't have copyright if there's no human. There's already been decided, and the Berne Convention says it has to be human. So the thing is, you would need protection a little bit like in the UK that computer-generated works, and by all means not protected under the copyright creativity requirement, where you need a human and it needs to be creative. So you have a sort of short-term protection. Martin Senflebens talked about that. So they have a kind of and I'll be very quick, a short-term protection that is not under the Berne Convention. That's my position on this.
Okay, wait.
On that, though, I think you're still understating the human role. I mean, if a simple prompt of paint me a cat like Van Gogh. Don't forget, though, what about our tool versus a competitor's tool versus another tool, the selection of the tool, what you do after with that?
Copyright for that.
Can I cut you short here? We've clearly here two different views on this. Axel, you're on the policy side. You will have to decide on which side you're going with. So, do you think that we need to protect humans as the exclusive source of creative content, or should we open up to machine content? Or perhaps, if I can push it a little bit further, a more general question. Do we still need copyright in the age of generative AI? If I, as a total ignorant in music, I can produce with the help of a generative AI dozens of songs in a few hours, and I can claim copyright on that. Why should that be possible? Can you answer this for me?
Yes, of course. So it's really not an easy way forward. So far, our understanding is we need a kind of an human contribution to it, and to what extent it might differ a bit, but I think it should be quite clear if we are asking for a mixed song from Taylor Swift and Queen or whatever, then and if I'm just changing here something what the fundamental what your machine is not doing, then all of a sudden this should be copyright protected. I'm not sure if this is then really has the quality of something. At this time, I have more the tendency to say we need still a kind of a human impact in all of these. Otherwise, all copyright protection will go to these big AI providing levels companies, and all of a sudden human beings or other human beings are out of it somehow. And still, everything what these machines are producing, there is still a bit of creative works in it from others. So it's just not out of the blue that they are creating something. They have been trained and learned and so on. But where you can draw a line, it's difficult to say right now. Still, at this stage, I would say we need a kind of an human intervention with a kind of a quality in it. And we can't just go ahead and saying, oh, now we are doing here everything, every second something is new and so on, and then this might be a kind of a bestseller or a hit or so, and then we are getting all out of it. Here, if we are following this idea of copyright and the human intervention and quality of creating, then we shouldn't say this should be protected, because you can produce these very easily by a machine, so that not everything what is created by a machine is copyright protected. So, and this is something where I would say probably we need to have a close look to it to find also here the thin line when it might be or should be copyright protected and when not. But just doing this like this now, I would say we shouldn't. And then there's no creativity in it by a human. It's just a machine who is following some rules. Yes, this might be somehow a kind of a protected machine, yeah. But yeah.
I think I agree with you.
Yeah.
To be very clear, I'm not saying that, and we do not believe that AI should be considered the legal author. But I think that humans that use these tools, I think human creators should benefit from the copyright system if they're using these tools, not the AI. I mean, but this is what you said. If a human is using these, yes, they should benefit from the copyright system.
It's just very basic information, giving a prompt that's so basic.
I don't think they'll make a lot of money from it. Yeah. I mean, but
oh well, it could be really, really cool. I mean, these cats with Van Gogh, they're pretty cool. When I did it, I was like, yeah, that's nice.
So there's actually a question from somebody online on this with regard to creation by machines, and the person asked, how would you argument that the prompt sent by a human is more than just an idea and is thus worthy of protection? So if I say, draw me a cat in Van Gogh style, that's just an idea. I haven't really produced it myself, but I use a tool to produce it. So here we come back to what is the minimum human content required to give an attribution of copyright? We are basically back, well, I have a background in trade policy long ago, and you had this local content in order to qualify for free trade and for exemption from tariffs on trade. What is the amount of local content? What is the amount of human content that you need? Can we at all solve this problem? How do you measure the amount of human content, the value of human content?
If you use the current rules in the current system, I mean, at least, it probably is about the same in every member state, right? You just have to give creativity, make free and creative choices when you're doing something. But the Court of Justice has said free and creative choices, like how many are they? 2, 3, 4, 5 choices? It never said how many you need. And when you look at the first case where the Court of Justice has said that, it was really these snippets, not even a whole sentence, but snippet of sentence from newspapers talking about the news. So it's really low. But then there's a real human doing the work behind this. It's just a few choices made by the human and not made by the machine. So I think maybe it's a discussion we need to have, and I agree with Axel. I mean, how much should the prompt be? How detailed should the prompt be? And the fact is, the output is not your output, it's the machine's output. So what do you get? Do you get the copyright in the prompt, or do you get the copyright in the output generated by the prompt? I mean, you know, surely the prompt is your prompt, so there's no question that you are the author of the prompt, and it's very quite detailed. There's enough sentences in it. Yeah, sure.
Okay,
But
so-
then the output is another question, because you didn't create the output; the machine did it for you. Yeah.
Let's throw open this debate to the audience and see whether other people have ideas or questions about this. We have a microphone that can circulate, so raise your hand if you have questions. Over there, and then over there.
So I just have a question on copyrighted output. If two people put in the same prompt into the same model, who would be the right holder under your suggestion?
Well, we go back to this issue. You know, first, it would be a very simple prompt, because two people getting a very long sentence with lots of detail, probably independently not going to come up with the same thing. But imagine we come to this problem, you know, you draw me a cat in Van Gogh style. If you say that you apply the current law, both people thought about the same thing, they did not copy each other, well, they should both have, if in that model, copyright in the generated output, if we agree that they should have copyright in the generated output, which is the question we don't agree on. But there's no issue, you know, you just apply the current copyright law, and then, you know, people have and the cat might not be the same, by the way, because the beauty of generative AI is it creates lots of different things even with the same prompt, right? So you never get the same answer often. So there's not really an issue, because it's not going to be similar, even if you give the same prompt, you know, and you're doing it again and again as the same person, you'll get a different answer. So I don't see a real problem with that. The problem is really not the authorship issue, like who is the holder of what, is whether should there be copyright in that. So before the question of authorship, I don't think is a, you know, the right holder of the you know, first the authorship, then the right holder. That's whether there is copyright in it in the first place. With no copyright, there's no right holder. Yeah. But you want to reply?
I would say you could, well, taking a step back too, I mean, I love these questions and they're great. I mean, you could answer that one right simply and say whoever did it first. That's one way to think about it. But I think it comes back to what you had said. It's also important to remember these models produce different outputs from one day to the next. They're fine-tuned, they change. But I would like to use your question to come back to what we were talking about. It's not like a guitar produces output on its own. It's not like a drum. It's not like a synthesizer. I mean, there's always a degree of human input to this. So I think it's important, in fact, if you're pro-copyright, to also see these as new tools that can go toward, that should definitely benefit from copyright protection. But it's the human creators that benefit from that, not the tools themselves.
Can you hear me? Okay, perfect. My name is George Constantino. I work for Lighthouse Europe. I would like to ask you, because you mentioned before that if artists go out of work, there will be no more data. Actually, I will do the devil's advocate. Of course, I don't want people go out of work in any case. But we can say that we have a gazillion amount of data with which we can train our models, AI models. We can also produce synthetic data out of outputs of AI and create a feedback loop for this model. So we have data produced by outputs, actually AI outputs. We feed them back. We make something new. Apparently, we're not going to run out of data, as I see it. And the other thing is that by this process, content creation is democratized. Let's say that we have people that have no talent at all. They were no good actors, no good painters, no nothing, no good singers, composers. And now they can compose music. We can have something creative out of it. And it reminds me of Gutenberg's printing machine that took the copying of text from monasteries, brought it to the people, and educated people, actually. You had more educated people back then. So this is an argument that somebody can use in order to, first of all, defend output. Secondly, say that, of course, it could be unethical for people to run out of work, but this is this actually evolution, something like this. And we have to cope with it.
Yeah, so a very strong argument in defense of innovation. Maybe Axel, you Do you see this as a balanced proposal, or?
Of course, we have to approach everything as a kind of balance, not only politically, also from the sectors. It's at this stage, I find this very hard to come to solutions, because we do not really understand what's going on. And we do have to find a way forward how we still consider a copyright law. So when our copyright, then when we created the copyright reform, all of a sudden you think, oh, you can't provide any longer 100% solutions. That's why everyone has to adapt somehow. So copyright holders, that something is slipping through. The platforms then might think, oh, I'm responsible or liable for something what is slipping through, and the users can't probably upload everything what they would like to upload. So we need to have a kind of a compromise situation, but we still would value property rights and intellectual property rights. And without these intellectual property rights, we probably are giving up everything. So there is no, then probably also no added value if we then trying to create something. Why should I do this just for fun if this is not protected, and so on. So this is, I would say, from my point of view right now, very difficult to balance, but we need to balance. Because we would like to see this is functioning, but we also would like to see that there is a protection from everything what is creative. And therefore we need this kind of quality. But so I can't give you really a kind of a satisfying answer for the future right now, but the need of balance is there.
More questions? Yes, please, in the back there.
Thank you. Quentin from the Federation of European Publishers. Hello, Axel. Beyond the question of copyright eligibility, of output, etc., I would like to go back a bit on the input side of things. Regardless of the status of the TDM exception, whether it applies or not to generative AI, what's your stance on transparency on the input? Because in the end, whether the TDM exception applies and then you have to express an opt-out or not, if you don't have any kind of transparency on what is used to train an AI, well, your right is pretty much worthless because you have no way to enforce it one way or another, and that's part of the current debates in the AI Act. So, should there be a transparency obligations on the inputs used for generative AI, and how far or detailed should this transparency should be? Thank you.
Yes, I think so. The answer is yes. I think there should be a transparency obligation, and it's linked to the opt-out anyway, right? If we apply the current law, so without it, you just, as you say, you can't enforce your right, and it's also very important for traceability, and especially if we want to give copyright protection to co-creation. Because then, you know, it will have, like you say, a footnote or some watermark or something saying, okay, this is generated by the AI, this is generated by the human. There needs to be something done about this. Otherwise, it's a free-for-all cowboy world, and everybody is... you just don't... And also, it's not good for the user. They don't know if it's been generated by an AI or by a human. I want to know, personally. And also, not only because I want to consume human stuff, but I want to see the difference. I'm interested. I'm curious. It's a human nature to want to know, you know, how good the AI is compared to the human, how different they do things, and then you can learn from it, and as a human as well. So I think if it's all blurred and we don't know what's human and what's not human, I mean, I don't think it's good.
So the discussion in the parliament is right now, we have to put transparency obligations to all what is. So in a kind of a general headline, AI has to be transparent and you indicate these and so on. But then you might have some exemptions, so for movies, news publishers and so on. This might happen that we are then coming to other ideas. But in general, and I'm agreeing with these, at the end to enforce your rights, not only for copyright holders, also if your personal rights are infringed, you need to know if this has something to do with this model. Or if we are coming, but please let us not discuss this at this stage at the AI Act, but if, let's assume OpenAI, Microsoft, or whoever it is selecting information on training these things, then you might come to the situation that this is a kind of misinformation. So if you would like to come to a certain direction, you're leaving out some sources, and all of a sudden this might be misinformation. And here we have also from a governance structure probably one day control what is in and what is not in. It might happen. It's just an idea for the future, but I still, because we can't be sure any longer what is a fake and what not. So we have to ask ourselves all the time, but if we are now allowing this can go on like this and everyone can decide what is now the fundament and what not, then all of a sudden you might end up in a totally disinformed society. And that's why I think there is a need also in governance structure without having trade secrets in the public, but we need at the end probably a kind of a control mechanism also on this fundament, where the model was trained on.
Your question was very much about the input side, I think, and some of what we just shared comes back to the output side. But on the input side, one, I don't think it's quite as straightforward and as simple as we might describe. There are different types of foundation models, some of which have very, very open data sets that you can use, whether it was Common Crawl that can be searchable. You can look for that. There are others that become much more, competitive, and there are implications about, well, who would get this information? One player may decide to train its model on certain data sets versus another, and there are competitive concerns that would come up in that space. And then you get to the level of detail that needs to be provided. Remember, these crawlers hit these publicly available sites in compliance with the copyright exception, but these are webmaster controls. You would have to create a list of time-stamped moments where you accessed all of that content. Where do you keep that? How long of a summary do you get? I mean, if you want millions and millions and millions of pages of that, I wonder what purpose it serves. A more simple way of answering the question is that I think some of these additional obligations would totally undermine the purpose of the exception in the first place.
I don't agree, because your AI can generate this in 1 second.
Not necessarily. Not necessarily.
I'm
Not
joking
necessarily.
a little bit
But
because I don't know the technology. But surely you've got traceability of that because you know what's inside. So you can just ask the computer software to just list me everything that you've trained. Poof, and then you have it. So
but if you're
I mean, obviously
optimistic
it's
about
dynamic, and you train every day. That's a different situation. But if it's a static one or you've done it at some point, it's pretty simple.
I would say the last part of the question I wanted to answer is, if you're optimistic about technology, I think you should also be optimistic then about the possibility for these tools to prevent that in the first place. This seems like an argument, once again, as I said in the beginning, of an enforcement of existing law. If the tools are not currently sufficient to protect and put up a blocker to make sure that your opt-out is watertight, then we develop new tools. And you can develop those tools in a way that they're also traceable. But you should be able to protect your content to make sure that it's not used for training if you don't want it to. And if somebody breaks the law, they break the law. And then you enforce the law.
Yeah. Okay. We are coming close to the end of this debate. In my view, what this debate has shown is that generative AI has exposed many gaps in European copyright directive and legislation. So maybe this is a task for the next commission, for the next mandate, to try to plug some of these holes, whether that's through the AI Act or through the Copyright Directive or some other instrument. But one last question, and for each of you, 20 seconds to answer. Do we have a choice in Europe in the sense that if other regions in the world, other countries in the world decide otherwise and go for a very liberal model, even if we protect copyright in Europe, won't we be overwhelmed by productions from the other part? Or are we going to geo-block all these productions? Are we going to become an island of low innovation while others have a boost of innovation? Estelle, 20 seconds.
Okay, well,
Do
first,
we have a choice?
Okay, we have and we haven't. So the first thing is obviously there's international conventions, there's TRIPS, so most of the countries are part of that, so they can't escape that. So they would have to revisit the copyright framework if they wanted to do something differently. So yes, there are possibilities to make these exceptions, you know, broad or narrow, etc. And yes, this is a global issue because indeed, you know, as we have seen in the past, you know, if you take one stance and the other countries do take the other stance, it's a fine balance. That's why I think it's a global issue, and Europe should talk to the other countries before doing anything. Yes, I agree, it should be tackled, but talk to the others, see what they're doing. That would be my 20 seconds.
You're working for a global company. How do you look at this?
I think you asked the question the right way. You know, you want every national jurisdiction or region has, you know, different ways of approaching this issue, and it'll be a question of the trade-offs that you want to make. And make no mistake, there are trade-offs, and you just have to determine what's most important. But of course there's a possibility that if acquiring or accessing training data for models is far more difficult in one place than another, well, you know where people will go to do the training. I mean, it's tautological. I mean, of course. And yes, it comes back to your earlier question about the difference between smaller player access to this versus bigger player access to this. So I think it's an important consideration if you're wearing your AI hat. You know, I think once again, there's a difference in having a copyright conversation. This is very much a copyright conversation. We need to have it. And I agree that the next mandate is going to be the space for that. And it won't stop. But if you think of the AI goals that you have in mind, I think it's important to be aware of those trade-offs.
Last word.
Even without I can't justify everything what I'm now saying so far, but this is now kind of a thing where I would say it's a global instrument, and probably we can't move on copyright like this fragmented situation what we have in the world. And therefore, yes, especially also in the EU, yes, but I have therefore the feeling these inventing new tools has to probably we should more streamline the copyright structures in Europe, transatlantic or whatever. On a global level, it would be wonderful to identify copyright holders and also the question of remuneration. I think this is something what has to be streamlined. And of course, now in the member state, they are all very proud of their traditions and so on. But in a digital age, we need to think about how we can work together better.
Thank you very much to the panel members for this very interesting debate. Thank you very much for the audience. And thank you everybody for attending this Bruegel event.